If you are planning to sponsor your spouse for a green card or are currently in the marriage-based green card process, then this information is crucial for you because new rules have come into effect in January 2026 that significantly impact how marriage green cards are processed, affecting processing times, documentation requirements, and interview procedures, and missing this information could delay your case by months or even lead to a denial, so it is essential to understand these updates fully. Hello everyone, and welcome to Visa Pulse USA, your reliable source for the latest in U.S. immigration news and visa procedures. I am your host, and today we are discussing the new marriage green card rules that have been implemented starting January 2026. These changes will affect couples who are applying for spousal green cards, whether you are applying from within the United States through adjustment of status or from abroad through consular processing, the United States citizenship, and immigration services known as USCIS, along with the Department of State, have announced several important updates that every couple needs to understand. So let us dive deep into these changes and explore exactly what you need to know to ensure your application is successful. Starting January 2026, there are several significant changes to the marriage-based green card process that directly impact spouses and families seeking permanent residency in the United States. The marriage green card, also known as the IR1 or CR1 visa for those applying from abroad or adjustment of status for those already in the U.S., is one of the most common ways people obtain permanent residency. However, immigration fraud through fake marriages has been a concern, which is why USCIS is implementing stricter verification procedures. Understanding these new rules is absolutely essential because the marriage green card process is already complex, and these additional requirements will make it even more important to prepare your application correctly from the start. The first major change involves enhanced documentation requirements for proving a bona fide marriage. USCIS has always required couples to prove that their marriage is genuine and not just for immigration benefits. But from January 2026, the evidence requirements are much more detailed and specific. You will need to provide more comprehensive proof of your shared life together. This includes joint financial documents, such as joint bank account statements covering at least the past 12 months, joint credit card statements, joint loan documents, or mortgage papers showing both names. You will also need to provide utility bills in both names, lease agreements or property deeds showing joint tenancy, and insurance policies listing both spouses as beneficiaries. Additionally, USCIS will require more photographic evidence showing your relationship timeline from dating through marriage and your current life together. These photos should be dated and include descriptions of the events. You will also need affidavits from friends and family members who can attest to your genuine relationship, and these affidavits will need to be more detailed than before, including specific examples of how they have witnessed your relationship develop over time. The second important change concerns the interview process. From January 2026, almost all marriage-based green card applicants will be required to attend an in-person interview, with very few exceptions. Previously, USCIS would sometimes waive interviews for certain cases, but under the new rules, interviews will be mandatory. Moreover, these interviews will be more thorough and intensive. Immigration officers will ask more detailed questions about your daily life, your spouse's habits, preferences, family background, and your future plans together. They may ask questions separately to both spouses to verify consistency in answers. The interviews may also last longer than before. Sometimes up to an hour or more. USCIS officers will be trained to identify red flags that might indicate a fraudulent marriage, so it is crucial that both spouses are well prepared and honest in their responses. Some questions might seem very personal or invasive, but they are designed to verify that you truly know each other as a married couple would. It is important to answer truthfully and consistently. If you do not know an answer, it is better to say you do not know rather than guess, as inconsistent answers can raise suspicions. The third significant change relates to processing times and case prioritization. USCIS is implementing a new system to prioritize certain marriage green card cases based on various factors. Cases where the couple has been married longer and has more substantial evidence of a genuine relationship may be processed faster. Additionally, cases where the U.S. citizen petitioner has a strong immigration history without violations will be given priority. However, cases that raise potential red flags, such as significant age differences, previous immigration violations by either party, or marriages that occurred shortly before filing, may face additional scrutiny and longer processing times. USCIS is also introducing a new online case tracking system that will provide more detailed updates about your case status. This system will allow applicants to see exactly which stage their application is in and what actions are pending. While this transparency is helpful, it also means you need to be more proactive in responding to any requests for additional evidence or information. The fourth major change involves conditional permanent residence and the removal of conditions process. When a couple has been married for less than 2 years at the time the green card is approved, the foreign spouse receives a conditional green card that is valid for only 2 years. To remove these conditions and obtain a 10-year green card, the couple must file Form I-751 jointly before the 2-year conditional period expires. From January 2026, the requirements for removing conditions are becoming more stringent. You will need to provide even more evidence of your ongoing marital relationship during the conditional period. This includes continuous financial commingling, ongoing cohabitation, and evidence of major life events you have shared during those 2 years, such as buying property together, having children, or making significant joint purchases. The interview requirements for removal of conditions cases are also being expanded, meaning more couples will be called for interviews. Even at this stage, USCIS wants to ensure that marriages remain genuine throughout the conditional period and not just until the green card is obtained. The fifth important change concerns background checks and security clearances. USCIS is implementing enhanced background check procedures for all marriage-based green card applications starting January 2026. This includes more comprehensive criminal background checks, financial background investigations, and social media screening. Both the petitioner and the beneficiary will undergo these enhanced checks. If either party has any criminal history, even minor offenses, you should consult with an immigration attorney before filing, because certain convictions can make you inadmissible or affect your ability to petition for a spouse. The financial background checks are designed to verify that the information provided in the I-864 affidavit of support is accurate and that the petitioner truly has the means to support their spouse. USCIS may request additional financial documentation, such as tax transcripts directly from the IRS, employer verification letters, and bank statements. Social media screening involves reviewing publicly available social media profiles to verify information provided in the application and to look for any inconsistencies or red flags. This is why it is important to ensure your social media presence aligns with the information in your application. The sixth change affects the financial requirements and affidavit of support. The U.S. citizen or permanent resident petitioner must demonstrate they can financially support their spouse at 125% of the federal poverty guidelines. From January 2026, USCIS is being more strict about verifying income and assets. If you are using a joint sponsor because you do not meet the income requirements yourself, the joint sponsor will also face enhanced scrutiny. USCIS may contact employers directly to verify employment and income. They may also request additional years of tax returns beyond the standard 3 years currently required. If you are self-employed, you will need to provide much more detailed business documentation, including profit and loss statements, business bank accounts, and potentially business tax returns. Assets can be used to meet the financial requirements, but from January 2026, only certain types of assets will be accepted, and they must be valued at 5 times the difference between your actual income and the required income. Real estate equity, bank accounts, and stocks are generally acceptable, but personal property like cars or jewelry typically will not be counted. The seventh point concerns immigration medical examinations. All green card applicants must undergo a medical examination by a USCIS-approved civil surgeon from January 2026. The list of required vaccinations is being updated and expanded. You will need to ensure you are up to date on all required vaccines, including COVID-19, flu, MMR, tetanus, hepatitis, and others, as specified by the CDC. The medical examination reports will also need to be submitted in a new electronic format through a USCIS portal. Previously, sealed envelopes were accepted, but the new system requires direct electronic transmission from the civil surgeon to USCIS. This is designed to prevent fraud and ensure the authenticity of medical reports. Make sure you go to a USCIS-approved civil surgeon, because examinations done by other doctors will not be accepted. The medical exam is typically valid for 2 years, but if your case takes longer to process, you may need to repeat the examination. The eighth change involves work authorization and advanced parole for adjustment of status applicants. If you are applying for a green card while in the United States, you can file for a work permit and travel document along with your green card application. From January 2026, USCIS is changing how these applications are processed. Previously, many applicants received their work permits within a few months, but under the new system, USCIS is implementing biometric requirements for all work authorization applications, which may affect processing times. The good news is that USCIS is also introducing a new combo card that combines work authorization and advanced parole in a single document, making it more convenient for applicants. However, you need to be careful about travel. If you leave the United States without advanced parole before your adjustment of status is approved, your application will be considered abandoned. With advanced parole, you can travel and return, but you should consult with an immigration attorney before traveling to ensure you will not face any issues upon re-entry. The ninth important point concerns expedite requests and emergency situations. Sometimes applicants need their cases processed quickly due to emergencies such as serious illness, death in the family, or urgent humanitarian reasons. From January 2026, USCIS is implementing new criteria for expedite requests. You will need to provide more substantial evidence to support your expedite request, and not all requests will be granted. USCIS will prioritize cases involving severe medical emergencies or situations where delays would result in significant harm. If you need to request an expedite, you should provide detailed documentation, including medical records, death certificates, or other evidence supporting your claim. Even with an expedite request, there is no guarantee your case will be processed faster, so it is important to file your application as early as possible and not wait until the last minute. The 10th and final major change involves penalties for fraud and misrepresentation. USCIS is taking marriage fraud very seriously, and from January 2026, penalties for fraudulent marriage green card applications are being significantly increased. If USCIS determines that a marriage is not genuine or that false information was provided in the application, both parties can face serious consequences. These include permanent bars from future immigration benefits, deportation of the foreign spouse, criminal prosecution with potential fines up to $25,000, and imprisonment up to 5 years. And the U.S. citizen petitioner may also face criminal charges even if the marriage started as genuine. But the couple divorces during the conditional residence period, the foreign spouse may still be able to keep their green card if they can prove the marriage was entered in good faith. But this requires filing for a waiver with substantial evidence. This is why it is absolutely crucial to be honest throughout the process and only apply for a marriage green card. If your marriage is truly genuine beyond these 10 major changes, there are several other important updates you should be aware of. USCIS is improving its online filing system, and from January 2026, more forms will be available for electronic filing. Electronic filing often results in faster processing times and easier case tracking. The fees for marriage green card applications may also be adjusted in 2026, so check the current fee schedule before filing. USCIS has also updated many of its forms, so make sure You are using the most current version of each form. Using an outdated form can result in your application being rejected. Additionally, USCIS is providing more resources and information on their website to help applicants understand the process, including video tutorials and detailed guides for couples going through consular processing, meaning the foreign spouse is applying from outside the United States. There are additional considerations. After USCIS approves the I-130 petition, the case is transferred to the National Visa Center and then to the U.S. Embassy or consulate in the foreign spouse's country. From January 2026, embassies and consulates are also implementing enhanced interview procedures similar to those at USCIS. Consular officers will ask detailed questions and may request additional evidence even at the interview stage. Some embassies are experiencing significant backlogs, so processing times can vary greatly depending on which country you are applying from. It is important to check the specific requirements and processing times for your particular embassy. So these are the comprehensive new rules that have come to the marriage green card process from January 2026. These changes may seem overwhelming, but they are designed to ensure the integrity of the immigration system while still allowing genuine couples to be together. My strong recommendation is to work with a qualified immigration attorney, especially if your case has any complexities, such as previous immigration violations, criminal history, previous marriages, or significant age differences. An attorney can help you prepare a strong application with all the necessary evidence and can represent you at your interview. If you choose to file on your own, make sure you thoroughly review all requirements, gather comprehensive evidence, and double-check everything before submitting. The marriage green card process is a significant investment of time and money, so you want to get it right the first time. I hope this update from VisaPulse USA has been informative and helpful for you. If you found this information valuable, please consider liking and subscribing to VisaPulse USA so you can stay updated on all the latest changes to U.S. immigration laws and visa procedures. We are dedicated to providing you with accurate, timely information that helps you navigate the complex U.S. immigration system. Also, enable notifications so you get alerted whenever we release new content with important updates. Share this with your friends and family members who are going through or planning to go through the marriage green card process, because this information is crucial for their success. Let us know in the comments if you have any questions or if you would like us to cover any specific aspects of the immigration process. In future updates, we read all your comments and try to address your concerns. Thank you so much for following VisaPulse USA. Take care and good luck with your immigration journey. Now, to delve deeper into the implications of these changes, let us revisit the enhanced documentation requirements, as proving a bona fide marriage is at the core of the process. And under the new rules, the need for joint financial documents like bank statements over 12 months ensures a verifiable history of shared finances, which helps USCIS confirm the authenticity of the relationship. Similarly, utility bills and lease agreements in both names provide concrete evidence of cohabitation, while insurance policies naming both as beneficiaries demonstrate long-term commitment. The emphasis on photographic evidence with dates and descriptions allows for a chronological narrative of the relationship, making it harder for fraudulent claims to pass scrutiny, and the detailed affidavits from friends and family add third-party validation with specific anecdotes that paint a picture of genuine interaction over time, moving to the interview process. The mandatory in-person requirement eliminates previous waivers, ensuring every case undergoes direct evaluation. The thorough questioning on daily life and personal details tests the depth of knowledge spouses have about each other, with separate interviews helping to spot inconsistencies that might indicate fraud. The extended duration allows officers to probe deeper, and their training on red flags equips them to better protect the system's integrity. Preparation is key, as honest and consistent responses are vital to avoid raising unnecessary suspicions regarding processing times. The prioritization system rewards established marriages with stronger evidence, accelerating their cases, while flagging those with potential issues for extra review. This approach aims to streamline genuine applications while deterring abuse. The new online tracking system empowers applicants with real-time insights, fostering proactive engagement and reducing uncertainty. For conditional residents, the stricter removal process demands ongoing proof of shared life, such as financial records and life events, to confirm the marriage's endurance. Expanded interviews at this stage reinforce ongoing verification in terms of background checks. The comprehensive criminal and financial investigations, coupled with social media reviews, provide a multi-layered security net, verifying not just legal compliance, but also financial stability through direct sources like IRS transcripts. This helps prevent inadmissibility issues and ensures accurate support affidavits. The financial requirements increase scrutiny, including employer contacts and extended tax records, particularly for self-employed or joint sponsor cases, underscores the need for solid economic backing, with asset valuation strictly defined to exclude less liquid items. Medical examinations updates expand vaccination mandates to align with public health standards, and the electronic submission enhances fraud prevention and efficiency. Though it requires using approved surgeons and potential repeats for prolonged cases, work authorization changes introduce biometrics that may slow initial processing, but the combo card simplifies documentation while emphasizing the risks of travel without parole. Expedite requests now demand robust evidence for true emergencies, prioritizing severe cases without guarantees. Penalties for fraud have escalated to deter misconduct, with severe consequences like bars, deportation, and criminal charges, yet provisions for good faith waivers in divorce scenarios offer protection for legitimate cases. Additional updates like expanded online filing promote efficiency. Potential fee adjustments necessitate checking current schedules, updated forms prevent rejections, and enhanced website resources aid self-education. For consular processing, the transfer to NVC and embassies involves similar enhanced interviews and variable backlogs by country, requiring tailored preparation. Overall, these reforms from January 2026 strengthen the marriage green card framework. Balancing security with family unification and consulting an attorney is advisable for complex situations to navigate successfully. Ensuring thorough preparation minimizes risks. This detailed overview from VisaPulse USA aims to equip you with the knowledge needed for a smooth process. Remember to stay informed through our channel for ongoing developments in U.S. immigration.